Ladies and gentlemen, brothers and sisters, good after, still morning, good morning. And I'm hoping we'll have a sense of loss if we're not inside here. So we have been fed. We have been around since 9 o'clock. Our spiritual needs have been met. Our brother, Reverend Dr. Leroy Walters, ministered to us spiritually. But one of the things we recognize about life is that we're not all spiritual beings. We're also social beings. And so part of our interaction here means that we need to learn certain life skills. We need to learn skills that are going to help our psychosocial behavior. And so coming right on the heels of this spiritual food, we're going to be ministered to in another form. And so this morning, we are very delighted to be looking at something that I think affects all of us. Believe it or not, I think once you have anything tangible and valuable, it is something that we need to look at how we dispose of. And so we are very, very blessed this morning to have eminent counsel. I use the legal language, Eminent counsel, our own sister Lisa Rhooms, who is going to be doing a presentation for us on wills and trusts. Lisa has indicated that her presentation also got some help from someone else, and so we want to recognize him this morning. Mr. Christopher Henry, who assisted, is a partner at Grant, Henry, and Rhooms. His practice focuses mainly on property and estate and probate. He has extensive knowledge in real estate and estates and probate matters, having the unique experience of being both on the representation and regulatory side of such matters. Christopher has served as legal counsel at the Real Estate Board and the Commission of Strata Corporation, and as legal counsel at the Administrator General's Department. Christopher sits on the board of several companies and also on the board of the Seaview Gardens Primary School as chairman. And so we're delighted to have him assisting with this presentation. But here with us is our own Lisa Rhooms. And I'll tell you what Lisa told me to tell you about her, and then I will tell you about her. All right? So Lisa says that she is managing partner of Grant, Henry, and Rhooms, and has a vast wealth of experience in commercial law and intellectual property law. She has worked on several local and cross-jurisdictional corporate financing and acquisition transactions, and has also provided advice on trusts and banking, financial, regulatory, securities, and structured finance matters. Lisa holds a Master of Laws degree in Intellectual Property Law from the Queen Mary University of London. She sits on the board of the Caribbean Coastal Area Management Foundation. That's what she says. Now let me tell you about Lisa. So Lisa is a child of Kingsgate United Church, and so we're very proud to say she's ours. Yeah? She's ours. All right? What she has failed to tell you is that she is a dedicated Christian and a member of this church. And so we want to welcome Lisa very specially and to say thank you, Lisa. You see, we love when people go get the training and come share it with us free. Not true? Yes. So we are very, very delighted to have Lisa this morning ministering to us. and helping us with our life skills. And I don't know who is outside, but I'm happy to see some younger people inside here because we tend to think that wills and trusts have to do with people like me when we're on the brink of death. Not true? Well, I wish I knew earlier to do some things which Lisa is going to tell us about today. And so, young people, take note. All right? Just to let you know, there is a sheet going around which we're going to ask you to register on. The reason is the information you're getting, you're going to be able to take with you. You know how much you'd have to pay for that? Right? So you can get it in your email or you can get a printed copy. And so I want you to indicate on that sheet whether you would like printed or emailed. Thank you very much. I'll sit down. Let's welcome Lisa as she presents.
Good morning, everyone. So this morning I will be presenting on wills and trusts, which are two ways that you can do estate planning. So this presentation is entitled Wills and Trusts, Estate Planning Before the Lord Calls You Home. Because after the Lord calls you home, there's nothing much that you can do concerning things that are left behind. So this presentation was prepared by my law partner, Christopher Henry, and myself, and I will be presenting the presentation. So if we could go to the next slide. All right, so just an introduction. So this presentation is going to be divided into two sections, on wills, and then I'm going to go into trusts because some of the information from wills will be replicated in trust. So just to give you some background. So a will is necessary essentially to make a plan for what happens to you after your death. And this is important because I'm sure as many of you know, when you don't leave a will, there is a lot of chaos after because there are people who feel that they should have gotten something that somebody else also feels that they should have gotten. So what a will do is set out the different assets that you have and who is going to be entitled to those assets. All right, next slide. So with a will, essentially, even from the beyond, you get to say who your beneficiaries are, who you want to be the person who is distributing those assets or winding up your affairs. Also, with a will, and we'll go into this a little further because there are two sort of processes, one where you have a will and one where you don't have a will. And the process of administration is where you don't have a will, and that process is a very long and can be a very drawn-out process. So it's always best to have a will so that, whatever it is that you have, there's a note of exactly who is supposed to be getting what. Next slide. All right. Next slide. So, go back. Right, so we're just going to go through some definitions. So a will is a document in writing which is made by a person and provides for the distribution or administration of his or her property after death. The persons that we'll be referring to as testators throughout the rest of the presentation, the testator is the person making the will. So as I mentioned, estate law is sort of divided into two separate concepts. One where the person dies with a will, which is called testacy, and then that will be dealt with by the process of probate, or where a person dies without a will, they die intestate, and that will be dealt with the process of administration. Now, there is another document which can be an addition to or can stand alone with a will, and it's called a codicil. So a codicil is, something that you might remember afterward that you want to attach to the will. So it can add to the will, or it can actually revoke the will. So it can say what I said in my will before, I no longer want, this is what I intend for the property, or it can, and therefore it can stand alone. So we're going to go through some of the formalities of a will. So it must be in writing, and it must be witnessed by at least 2 people who are preferably not beneficiaries. Now, there used to be in the law where if they were beneficiaries, they wouldn't be able to get the gifts at all. But there was an amendment which says that if your beneficiaries are also witnesses, they may be able to benefit if you can prove that there was no undue influence. But now, proving that there is no undue influence in the sense that you never tell them something or they never tell you something, and there's some kind of proof as to the fact that you didn't essentially hover over them and say, give me this. Unless you're able to prove that, your gift will fail. So it's usually best to not have any of your witnesses be people who are benefiting under the will. An executor is the person who will be dealing with the distribution of the assets under the will, and it is always recommended that you appoint more than one executor. Now, the reason for this is because an executor may die before you, an executor may refuse to act, or there might be any other reason that the executor just doesn't want to be the executor anymore. And in that case, where you only have that one person under your will, that creates a whole other set of problems. So it's usually very important to get more than one person, just as kind of a backup. So the will must be signed at the foot of the will by the testator in the presence of the witnesses who must be present together at the same time. So you all need to be in a room together to draft up the will, have it witnessed, and have everybody sign that they saw the testator sign it, and that the witnesses witnessed the testator signing it. So that is point 5. The witnesses must attest to the will in the presence of the testator. So they must say that they acknowledge the contents of the will and they saw the testator sign it. Just for a point, your witnesses, it doesn't matter if, for any reason later on, they're proven to be mentally incapable, or if they die before you. So that's not an issue, as long as it is that they have signed and attested properly. There is also no reason to tell anybody what is in your will. It can be secret until you pass, and then everybody finds out then what it is that you've left to them. You don't need to tell anybody. Only people that need to know what's happening are the witnesses who would have been there, so that if anybody say, no, that couldn't possibly be it, the witnesses will be there to say, this is my signature. I saw when he said that this is for you. And so that's, again, one of the important things about having witnesses and having them attest to the fact that what is in the will is truly the intention of the testator. So, as I mentioned earlier, witnesses getting gifts where they're also, beneficiaries, you need to show that, you didn't force the testator to give you this gift. So it's really best to use a neutral third party. A marriage automatically revokes a will. So what this means is if you had a will before you were married and you got married, you need to do over your will. It is revoked because there are certain rules in relation to spouses. So if you don't mention your spouse in the will, there are certain things that are going to kick in law. So your marriage automatically revokes your will. So if you have a will and it was done before you got married, you need to do it over. All right, so we're going to talk about some um, alterations to your will. So, no obliteration, interlineation, or other alteration made after the execution of the will shall be valid unless without this alteration you wouldn't understand what the will was saying. Now, an obliteration is where you take a piece of, you take a pen and you mark through it. An interlineation is where you put like a little arrow and you write in the middle of the words. And an alteration, you stick something over the side or you just drop in something. So none of these will be valid after the execution of a will unless without them you wouldn't be able to understand what the will was saying. And for these, if you put them in, they have to be signed by the testator and the witnesses somewhere in the margin or very close to the alteration, or you can, at the foot of the will, say that, basically to insert a line that says that the alterations above are what I intended. So you put a little reference to the alterations at the bottom when you're signing. Now, alterations, interlineations, obliterations may not automatically revoke a will. A will is revoked by an intention to revoke a will. And how a will can be revoked is by another will, by a codicil, or by the testator actually tearing it up, burning it, or otherwise destroying it. Otherwise, your will stands. So if you have two wills anywhere, the one that you don't want to be your will, tear it up, burn it, so that it's very clear at the end what your intentions are. So no will that is revoked can be revived, which means that if you have a will and you came up with something else, or you wanted to give somebody else something, and you wrote another will that revoked it, that first will is no longer your will. It cannot be revived. So now in terms of gifts, so what happens if somebody that you put in your will dies before you? If a person that you put as a recipient of a gift in your will dies before you, unless you update your will, that gift is going to fail and fall into your residuary clause, which I'm going to explain what that is. So if something has happened, it's always good from time to time to just make sure that your will is updated so that there's nobody in there that you don't want to be in there, and there's nobody in there who has died or for any other reason you don't want them to get a gift. So the residuary clause in a will is usually the thing that says, and everything that I have not made reference to goes to X person or should be dealt with in this way. So when gifts fail or lapse, they fall into this clause, and whoever you might have said to all my other properties, I give John. John will also get some of the gifts that have lapsed or failed if they have lapsed or failed. So, next slide. For example, where you gift a piece of land and the testator decides to sell the land before he dies, which is his right, it's his, so he can sell it before if he wants to. If you were supposed to get that piece of land in the will and it says in the will that you're supposed to get that piece of land, you're not getting that piece of land. The gift will fail. So again, very good to update your will from time to time to take out anything that no longer exists or, it no longer exists. So you might be wondering, what can you gift? What can I give to people? You can give anything irrespective of the value. And there's a little bit more of a technical area to this, which I'll get into, which is what you can't give. So you can give solely owned property, you can give money, which is in cash or accounts, you can give shares, motor vehicles. If you have an art collection that you have, you can give that, shoes, clothing, collection of brooches that you might have, some lovely jewelry that you might have, you can gift those. What can you not gift? You cannot give things that you do not own or have sole ownership of. That means if you have a car that isn't quite yours, it still belongs to the bank or finance company, you can't quite give that until you've paid that off. Because what will happen is if you give it to somebody in the will and you haven't paid it off, the car still belongs to the finance company, and so the gift is going to fail. Similarly, if you have shares that you haven't paid fully on, again, the company can always call back for those shares that you haven't paid for, so you can't give it to somebody because that gift is going to fail. Also, there is a very, next slide, there is a very important concept for property ownership. Now, there are two sorts of property ownership. One is joint tenants, and one is tenants in common. Now, joint tenants is a situation where what happens on the death of one joint tenant is that there's a concept called survivorship. So in a joint tenant situation, if you own land with a person in a joint tenancy, when you die, your rights automatically pass to the surviving owner. So it's very important to look at how you own things in case you want to give them away in your will. Because, for example, in a joint tenancy situation, you can't give that to anybody. It's going to pass to the surviving tenant. However, in a tenancy in common, which is, I think, one of the best ways to do ownership, your portion of the property is solely owned by you, and therefore you can will that part to someone. Okay, now I'm just going to go through the procedure for probate. It's actually can be a long process, but it's a much easier process than, for example, administration, which we're going to get to. So the process for probate is where you die is where your executor starts their duties. So your executor should retain an attorney and gather the particulars of the estate to find out what properties you have where, and looking through the will, look at the different things, look at if there's anything that's not in the will that may fall into intestacy. So let me just stop to make a point. If there's anything in your will and you don't have a residuary clause, you haven't willed it, you have this property, you haven't willed it, and you don't have a residuary clause, that property that is not accounted for is going to fall into intestacy. So you must make sure that you put in your will all the things that you have, update it from time to time with things that you might get, and you can also put in a clause which says, and my future things, which will also come in a part of your residuary clause. So the executors need to gather the particulars of the will, retain an attorney who will check through the will and see that everybody is validly appointed. The attorney will need a couple of details, which is the deceased's full name, place of abode, last place of abode, occupation, place of death, place of interment, age, TRN, the executor's full details, being their present address, occupation, and TRN. The attesting witnesses' full name, present address, and occupation. All the details of the assets, being your realty, which is your real property, any kind of land, apartment, any kind of building, and your personality, which are your personal items, whether those are your jewelry, your motor car, money. So for this process, you'll also have to obtain a valuation, a formal valuation of these items, because that's going to be important for determining the value of the estate when you need to pay over those taxes to the government of Jamaica. So we're also going to be looking at the liabilities, including details of mortgages, any death expenses for the funeral, medical expenses, and you must also get the receipts for these items. Now, I'm going to just make another point on mortgages. So a mortgage doesn't quite work in the same way as your motor car. So even though the bank, it's still your property. You're using it as collateral, but it's a two point. Where you have a mortgage and the estate is able to pay off the mortgage, then that gift will not fail. If your estate is unable to pay off the mortgage, that is where the gift would fail. All right, so the attorney will confirm the assets of the estate and then draft some paperwork for the executor. This is the oath of executor, the grant of probate, which is the actual document that you will get back signed by a judge after, and you will need to provide a death certificate. If there's no death certificate, then you do an affidavit in proof of death. If the probate is a year after the death, a year or more after the death, you will also have to do an affidavit of delay. So it's really best to get the process started as soon as possible to minimize some of the paperwork. And there will also be an affidavit of due execution where there is no attestation clause, which means that your witnesses failed to attest, or they didn't do it properly, or the registrar has some concern about your attesting witnesses. So it's really best to just do it properly from the very beginning so that we don't have to go through some of this trouble. So after all the documents are filed, are executed, they will be sent to the stamp office for assessment of stamp duties, and stamp duties will be based on the value of your estate, which is why you need to go through the process of getting all the property valued. Then your attorney will file the documents in the probate division of the Supreme Court, and the attorney will provide a revenue affidavit, which is to be witnessed before a justice of the peace. And for this purpose, your executor should be very careful in making sure that they give all of the necessary information to the attorney in terms of financial statements, valuations. I should also mention here, and it's on the slide, that the matrimonial home or the principal place of residence is exempt from transfer tax. So you won't have to pay transfer tax if your spouse is the person who, there should be that person that the property goes to. It's going to be exempt from transfer tax. The next step is that once all of that goes over, the grant of probate will be given by the court, and you should at this time notify any people that you owe or the estate owes in the local newspaper. And if you have any shares, for example, the executor will be preparing, the transfer, and then you will have to pay transfer tax on the things that will be given to people. So transfer tax on 2% on your property and other assets that you have left for persons. At this point, you'll also have to pay the debts of the estate from the estate and transfer any land that needs to be transferred. And then, next slide. And then after you do the land transfers, you transfer the cars and the other personality. Then you pay your attorneys, and then the executors get paid from the estate. And this is a 6% commission on all monies passing through their hands. Generally, a probate, if it's fairly straightforward, will take about 12 months. So what happens if you don't leave a will? Where a person dies without a will, failing to provide for what should happen to their assets, it falls into intestacy. And this is governed by the Intestate Estates and Property Charges Act. And essentially this act will say who can apply to be the administrator of your estate. So it's not going to be somebody necessarily that you chose or would have wanted to do it. It's usually a beneficiary who stands to benefit, so they're interested in getting the estate administered. So in the in intestacy, what happens is that who you want to get something may not get something, because there's a particular order which is set out in the act. So the first person to benefit is your spouse, and your spouse gets a half share. And so if you have no children, your spouse gets pretty much everything. If you have children, your children get sort of a half share and your spouse gets a half share. If you don't have any spouse or children, then it's your parents. If you don't have any parents, then it becomes your other eligible relatives, your brother or your grandparents. And if you have none of these people, it goes back to the Crown, which is the government of Jamaica. So the procedure for probate is very similar to the steps for under a will. But what happens is, because you've not left direct instructions, one of your beneficiaries will need to apply to the Administrator General to essentially ask for permission to administer your estate, which is a long process and sometimes an expensive process, because an attorney will need to go and draft some more documents for you, for the person who wants to be the beneficiary doing the administration. They'll have to draft some documents for you, submit it to the Administrator General, who will then give her consent by a certificate. Now, the documents to be filed are the oath of administrator. You will do a death certificate or an affidavit for proof of death. If, again, it's 1 year after, an affidavit of delay, and a revenue affidavit, which we spoke to. The documents will then be stamped. In the same process, it will be based on the value of the estate. The documents are filed again in court. And once the assessment comes back, the taxable assets can be transferred. Also, you will need to advertise the administration in a local newspaper for 2 consecutive weeks, so that anybody who feels that they might have some kind of claim has the ability to look and see. And it's usually in the legal notices section in the newspaper. Once you receive the grant to go ahead and do the administration, you transfer the land first, you distribute the personalty, motor cars, money, you again pay your attorneys, and the administrator is also entitled to a 6% commission. Now, this process can take anywhere between 2 to 4 years. Do not put your families through that. It is very, very hard. Okay, so we're going to move on to trusts, but if you have any questions on wills, I should probably take them now.
because I made will. No, not only one, it's more than one. I works with the government. I did one there. I save a lot. I love to save. I had 4 children. I had 3 on my last will because of reason. That is one. I put my last son to be known publicly now. Now, he's the one who stand with me. All of them stand with me, but that one is very important. So I put him as what? Trustees? Executive? Executor. So that is one of the things I am asking. He had to go to the probate. I did the will already. I had all the things, and we had joined things. But in what I understand, I don't know if I'm understanding clear, can he be the person to do all these things because I want to probate the will to make sure everything is clear? That is my understanding that I want to do as well. Another thing in shares, I had a problem with shares. I had some shares which I had one of my child on. I needed to remove to put everything together. But I was told I had to go through lawyers and this and that. I bought it when she was very young. So I need to know now the condition of that shares.
Okay. So for the first part of your question,
Yes.
yes, your son as the executor and being the person who's benefiting under the estate, he will be able to do that, and also the administration of the estate. You said you have more than one will.
Yes.
You shouldn't.
As soon as I go along,
So
I made will. That is my intention.
So you must have one will. You can update the will,
Okay.
but you mustn't have more than one will, because where you have more than one will, that's gonna cause a problem.
Okay.
Especially if it's not the same thing in the 2 wills.
Thanks. As soon as I progress in, I made a will.
Yeah. So if you have more than one will, please take this opportunity to put them together in one document.
Okay.
So that all of your intention is in one document.
Thank you.
In relation to the shares, if your child's name is jointly on the shares, you both own the shares, and that shouldn't be a problem if you should pass. But if it is that you are having a difficulty and she's not on any, so you think she's on it, but she's not on any of the paperwork, and you want to add her to the paperwork, that's something that you can do while you're alive to make it a little easier. Yes, so that's the answer to those 2 questions.
Okay, so I don't have to go to the lawyer to deal with it.
No, it depends on what the situation is. If she's not on the paperwork and you want to put her on the paperwork, then yes, you're going to have an attorney do some share transfer forms and just let her interest be known. Or you could just will the shares to her and make sure in the will it says share certificate number 1, which encompasses shares 100 to 10100 belongs to this person, and make it really clear that those shares are for her.
Okay, thank you. Because what if she died before? Or what if I died and I didn't really well? Thank you for getting these things to me today, that I can get my hats together. Thank you.
My question is, counsel, sometimes 2 persons are married, one dies. Before we get to that, two persons married and they have property in as joint tenancy. One dies, so the property falls to the surviving, right? But then the survivor decides to be married again, especially, let's think about male, because I know of instances where it creates problems. The male decides that he's gonna be married again. Can you hear me? I'm sorry. Yes. And so he has now a new wife. Tell us about the technicality of that matrimonial home.
Okay, so let me not start at the matrimonial home. So where the person dies and the rights pass to the survivor, that person now owns it entirely. So that's the first part. So the new husband or wife is not entitled to certain things so certain property they're not entitled to where the other person owned it fully. Now, the matrimonial home is a very interesting piece of property, and it has had a lot of case law surrounding it and what it is, and how do you determine whether it's the matrimonial home because of the kind of things that flow from the matrimonial home. For example, in the presentation, I told you, because it's supposed to pass to the other spouse, you're not going to pay transfer tax because that would be a little wicked for you to get half of your own house. So with the new matrimonial, with you remarrying, once the other person can prove that this property has now become the matrimonial home, then they're going to be entitled to that. So again, yeah, so it's gonna be your sort of, well, to be fair, if they're still alive, your share in the match, because it's essentially was all of yours before when your first person died. So when you get remarried and it becomes the matrimonial home, it is the other person who is now entitled to that because it's a matrimonial home. So,
Is there a time frame associated with that?
so
Or from day one?
so not from day one. You will have so there's no specific time frame. But if the circumstances, and if there is contention, and and for example, a court has to look into the circumstances, all of the circumstances, and make the assessment that this has now become the matrimonial home. So there's no real, after 1 year it's a matrimonial home. But if it is that all the circumstances, and again, it's not really an objective standard, it's, when there is contention, then, the court will come in and put in some different, look at different situations, and then try to determine whether, under the circumstances, it has become the matrimonial home.
The challenge I have seen or I've heard about is that when one party dies, then it falls to the survivor. Yes, that's fine. I don't have a problem with that. But when you remarry, and I'm using male and female now, the man remarries, and I don't know if it applies to the male as well, but when the man remarries, if he chooses, then the new wife is not on the title as in a joint tenancy. The title is still owned by the survivor. However, I understand that the new wife is entitled to 50% of the matrimonial home. That's my understanding. Children or no children, the survivor, I'm told, I'm not a lawyer, just out of little experience, right? You can, I'm told, you can do what you wish for your children or whoever with your half, but a half of it belongs to the spouse. And it's only the matrimonial home, I get that applies to. But you can enlighten me, I'm not, it doesn't apply to me, and ever going to apply to me, but I know of persons who have had some situations, and sometimes they come to you for a little advice, and you can't just talk and then send them to a lawyer. But that's what I have found out. Thank you, Sister Lisa.
Yes, so there have been cases where once it is shown that it's the matrimonial home, it goes to the other person. Yeah, because so again, the matrimonial home is a very tricky situation because it is for the benefit of you and your spouse. Question? Other question?
Oh, okay.
While you're waiting for that one, let me ask a question, a follow-up to that.
Okay.
So here it is now. I was married to this man. He dies, and so I am survivor. We own jointly. So the property is now mine. And I'm marrying another man. What if I choose to leave that property alone and we go rent somewhere? Do I solve that problem?
Yes.
Aha! You see? I had the solution. Don't live in that house. Rent out that and go rent somewhere else.
So if you choose to go the way Auntie Veronica is saying, then you leave that property in your will to whoever you want. Because it's no longer the matrimonial home, it's just a home. It's just a house.
May I?
Yes, yes, good up.
Okay. All right. So two questions. Does the poor man's will work? How does it work? Can you speak on that a bit?
Yes,
That's one.
so a poor man's will is essentially where you go to the pharmacy and you buy the wills form. That does work. Yeah, it does work. Anything actually works so long as it follows the formalities. So any piece of paper that you jot something down on in front of two people and you sign it and you say, this is my last will and testament, will be your will.
Second one, thank you. How does the will affect common law unions?
So common law unions, after a while, a common law person becomes your spouse within the law.
What is a while?
I think it's 7 years. And they are entitled as a spouse.
Okay. Thank you.
Afternoon. Like a situation that I have. My aunt died. My aunt died, she didn't leave her will. I am the only living relative. But she had adopted a daughter. Well, she adopted a son and daughter, but the boy has died. So who is now the next of kin?
Okay, so it depends on whether we are now speaking about I adopt you as a child, but I don't have any paperwork, or a legal adoption. A legal adoption, that person is treated in law as if they were born from you at birth. And then in the steps for intestacy, there's no spouse, the children are next on the list. If you are not quite there, if there are children before you.
Okay, because I get the impression that it was foster care. So I don't know, I don't know of any going through the legal process of
Right. So if it's
adoption.
not actually a legal child, meaning there is a certificate of adoption, then that person is quite treated in law as a child for the purpose of benefiting.
Okay, so I have to go sort out
So
the.
it would be, if there are no people in front of you on the list of intestacy, then you're next.
Okay, thank you.
My question to you is what happens if a sole executor dies before everything in that will is distributed? A sole executor.
So
Thank you.
if a sole executor dies, then it's almost the process of intestacy, because now the administrator general will have to essentially appoint either. So it's going to go two ways. Somebody can apply to administer the estate, meaning a beneficiary, or if there's nobody who wants to do that, then the administrator general will appoint an administrator to administer the properties.
So we're going to take 3 more questions. Otherwise, you have to come and see me, and I will manage Sister Lisa's business.
All right. Can I make just a simple
Right?
question?
3 more questions before she goes on to.
Can the testator designate his spouse, or does that have to follow a legal kind of definition?
Designate who their spouse is. So the spouse will be the person who is on your marriage certificate, or the common law spouse.
Okay.
No, there's only one. There's only one.
Okay.
In law, there's only one.
Okay, Lisa, my question is, as a single parent, can my will just be all that I have that is of worth goes to my child? That's my will.
Yes, you can do that, but it's usually best to specify what the things are so that your executors don't have a hard time trying to figure out what you have. Because when you die, they'll have to go and locate a property that nobody knows that you have because it's not in the will, or if you have a piece of property somewhere in the country that nobody knows about. If nobody knows about it and you haven't specified it, no one will know to put it in your estate, and it's going to, at some point, fall to people who you never really intended it to fall to. Could be somebody later on just decide to squat on the land because they don't see anybody ever coming back for it. So specify all your assets. So specify the land by referring to it with the volume and folio number. If you have share certificates, put where the shares are in, the share certificate numbers. If you have bank accounts, put what bank and the numbers. Be very specific in the goods so that it's not very hard for your executor to find out after what you actually have.
All right, so I know I said this would be the last one. Here's how we're going to do it. She's going to do the presentation on trust, and if we have time, we'll take a couple more questions on wills, okay? So we'll take the last one. I know there are some other persons who have questions.
Okay, Sister Lisa, if I have an insurance policy, I've named a beneficiary, my bank account has a joint holder, my house has another person's name, jointly owned, do I still have to make a will?
So those might not be the only things that you have, but you should put things that are not jointly owned, and you can just make reference to what is jointly owned. Yes, when you die, your insurance policy is gonna automatically pass to the person who is on there, and if your bank accounts have another person on there and they have access to that money, then that also shouldn't be a problem. But yes, still make a will.
Okay, thank you.
All right, so we are going to go on to trust, and as I said, if we do have a little time after, we'll take a few more questions. And if it gets too intense, then I'll do the offering.
All right, so trust. A trust is another way that you can essentially make a plan for what happens after you die. And it will deal again with the distribution of your assets, who you want to be the person distributing your assets, and your beneficiaries. There's different types of trusts, and there are certain types of trusts which can determine what happens to you while you're alive and who you want to benefit while you're alive, and also who you want to benefit after you've died. Now, as you would have seen, the probate process can take up to, 12 months, maybe more, and the administration process can take several years. So a trust essentially is one of those ways to avoid some of these processes. So similar to the will, the trust will direct who is to get what, and that ensures that only the people that you intend to benefit from your estate benefit. As I said, there are certain trusts that can provide for you while you're alive. So we're going to look at some definitions. A trust is an obligation binding persons who are trustees to deal with property over which they have control, the trust property, for the benefit of other persons who are the beneficiaries. A trustee, like an executor, can also be a beneficiary. A trust is created by a trust instrument or a trust deed, and this is the document in which you will state how you want your property to be dealt with. For the purpose of this presentation and moving forward, the settlor is the person who creates or grants the trust. So the nature of trust is that what usually happens in a trust is you create a trust deed and you vest the trust property, or you give the trust property to the trustees who hold that property on behalf of the beneficiaries. And this is different from a will, where when the person dies and the estate is probated or administered, the property is going to go directly to the beneficiaries. So a trust is sort of it's a pre-death and pre you wanting to give people things process, and you'll see why I say that. So a settlor may utilize a trust because what will happen is they can appoint trustees, and trustees during the life of the trust, before anybody gets anything, can deal with the trust property, safeguard the property, and then they can do the application of the trust in line with what the deed says. So, for example, where you make a trust that says, the trustee holds this property for the benefit of my children. The trustee is supposed to use that property and make the property productive, and they can do this by renting the property. So you're not getting the property right away because usually the person is still alive. So you're not getting the property right away until the person dies or the trustee is otherwise directed to give the property to you. So you trustee can rent the property, or in the case of money, the trustee can invest the money until the person who is supposed to benefit is to benefit. So trustees are sort of unlike executors who sort of pop in once you've died. Trustees are not passive actors during the term of or the life of the trust. They are responsible for ensuring that the trust is making as much money as it can for the beneficiaries, or the property is being used for the beneficiaries. So one of the advantages of a trust is that it is flexible. You decide what you are going to put in, when people are supposed to benefit from the trust. So it is like a will in that sense, but also while you're alive allows you to have some control over who is given what, when they're meant to benefit, and can control things like the destination of family property when you die. So with a trust, for example, the settler can actually make provision for what would happen after a particular person gets the property. So you may say, the settler may say, I'm the beneficiary while she's alive is my wife. After she dies, the property goes to my children. If it were a will, then you would have just left it to your wife when you die. But for the life of your wife, you can say, this property is for her benefit while she's alive, and when she dies, it goes to the children. So this property is not passing into your wife's estate. It is for her benefit while she's alive, and then it is to go to your children or whoever you designate after that. That's one of the things about a trust that you wouldn't be able to necessarily accomplish with a will. So the will, you can make provisions for things like including that $500 or whatever amount out of your trust is supposed to be used to upkeep your grave. Also, you can make things like, if you left behind a dog, you can say $10,000 a year is to be used for the benefit of my dog. Yeah, so you can make provisions for that. So I'm just going to go through some of the differences between a trustee and a personal representative. And personal representative meaning both, when you have a will and it's your executor, or when your property or things falls to administrator and an administrator is appointed. So an executor's duty is to wind up the estate, pay the debts and duties of the estate, and hand over trust property. A trustee manages and administers the trust estate for the life of the trust, or as long as they're a trustee, which can be a very, very, very long appointment. The beneficiaries under a will have no entitlements to anything in the will until the deceased property is probated and or is administered, and they get the assent from the personal representative that this property and this personality now belongs to them. The beneficiaries in a trust have an interest in the trust as soon as the trust takes effect. So as soon as you create a trust that says, this trust is for the benefit of my wife, remainder to my children, your wife has a direct interest in that trust as soon as you have created the document to say so, and the trustee has a duty to ensure that everything is going right with the trust for the benefit of your wife. So a trust, an administrator or a executor, their duty is to the trust as a whole, so they don't have any real reason or they don't have any real duty to any individual beneficiary. So they have a duty to, at the end, say that this person is supposed to get this person is supposed to get this person is supposed to get this, and administer the entire estate. Now, when you put in a trust that, for example, the trust is for your wife, and then for the benefit of your children, you have a duty to the wife to upkeep the trust for that period, and also you have a duty to the children who are also supposed to be beneficiaries. So there are two types of trusts I want to talk about today. There are many types of trusts, but the two that I want to talk about today are first living trusts, and then I'll go on to what testamentary trusts are. So a living trust allows the settlor to be both the trustee and the beneficiary, so you can keep hold of your property for your benefit. And it can also be that in that same document, you say what is supposed to happen when you die. So, because what generally happens, and we'll get into it with a trust, is that all the property is already with someone who is the trustee, then you don't have to go through the process of administration, because the person who is holding the items on trust will be able to just distribute it according to the deed. So you don't have to go through the process of getting, revenue certificate and all of these things, because you would have already known from the beginning that you're holding this property on trust for John. So when the settler says John is supposed to get this property, you give the property to John. So a testamentary trust is one that takes effect on the settler's death. And for this particular type of trust, it must be done in the same way as a will in terms of the formalities. So it needs to be in writing, it needs to be signed and witnessed. Now for trusts, there are some more formalities, but there is a concept which is referred to as the 3 certainties. And a trust will not take effect unless there is certainty of words and intention, certainty of subject, and certainty of objects. So certainty of words means that the settler must show an intention, not simply a moral obligation, but an actual intention to create the trust. And this intention must be sufficiently clear. So there are no real special words that you have to use, but the fact that you're creating a trust, it must be clear that that is what you're doing. So words like, I wish for this person to get this, or it is my hope that this person will get this, or I desire that this person is to get this, shows sort of a moral obligation rather than an intention. So be very clear in saying, I want Peter to get this. This is to be given to John. Be very clear. So certainty of object speaks to the fact that it has to be clear what is the property that is being held on trust. Is it land registered at volume 5, folio 7? What is the land, or what is the property? And also, what is the beneficial interest that each beneficiary is to receive? So is your wife to receive all of this property for her life and then it passes to your children? All of those things need to be sufficiently clear. Where the beneficial interests are not clear, similar to in a will where it's unclear, the gift will fail, and what will be created is a resulting trust, which is essentially falls into a sort of residuary situation, and then you'll have to deal with that separately. So certainty of objects refers to the people who are to benefit from the trust. They must be sufficiently clear. You must be clear in who the beneficiaries are. Certain descriptions are fine. my first daughter, that's fine. Everybody knows who your first daughter is. Should be sufficient. You hope. Should be sufficiently clear. Do not use things like my dependents or my old friends, because nobody knows who those are. And therefore, the gifts to these people are going to fail and lapse. So, generally, for trusts, what happens is that the trust property and other items are given to the trustee. So the legal interest in those items are given to the trustee. So what this means is if you have a piece of property, what you do is you transfer that land to the trustee to hold on benefit for the beneficiaries. So in a will, you would have kept all of those properties until you die, and then you go through the probate process. But in this process, while the trust, establishing the trust, you're going to transfer your property or your personality to the trustee who holds it on trust for the beneficiaries. So there must not only be a declaration of trust, but you have to do this process of vesting the trustee with your property. So in the process of land, you transfer the land to the trustee by a deed of conveyance for the benefit of the beneficiaries. In the case of personal items, you do this by delivering the physical items to the trustee or by a deed of gift. In the case of shares, which requires a share transfer, you put the share transfer in the name of the trustee who holds it on trust for the beneficiaries. So in the share register of the company, you will see Trust of John Brown being the owners of the shares. And then when it is time for the beneficiary of those shares to get the shares, then the trustee will execute the share transfers and just transfer the shares directly to the beneficiaries. Now, you must appoint, like you must appoint executors, you must appoint trustees. And where there is no trustee who is identifiable, that trust is going to fail. In Jamaica, there is a requirement for either you get a trust company to be your trustee, or you must have at least 2 people trustees, 2 individual human trustees. So you can also appoint more trustees during the life of the trust. It's not only the persons that you put on when you created the trust. Trustees, where trustees die or they might be outside of the jurisdiction for more than 12 months, where they want to be removed, where they refuse to act, or they're unfit to act or incapable of acting, this trustee can be removed and replaced. So a trustee can also retire, and usually there is a provision in the trust deed that says how they retire, or the beneficiaries can agree or consent to their retirement. So this is a quote, and it's also, this presentation is for you to consider if you are going to be a trustee for someone. A trust is an office necessary in the concerns between man, and if faithfully discharged, is attended with no small degree of trouble and anxiety. It is an act of great kindness in anyone to accept it. So if you're thinking about, or someone asks you to be a trustee, please remember this quote. It is a very onerous task. So, next slide, yes. The duties of a trustee are onerous, even more so than an executor and administrator, because they are ongoing for the life of the trust or as long as the trustee remains a trustee. They are to manage the trust in the same way as they would in dealing with their own personal affairs. On appointment, trustees are to confirm that they're properly appointed ascertain the property in the trust estate and familiarize themselves with the terms of the deed, so you know exactly who is in there supposed to be receiving what and when they're supposed to receive it. And the trust property, they're to ensure that it is under their control. So you must ensure that any property is transferred to the trust or any shares are transferred to the trust so that you can deal with that property. So if there are any payments that are owing to the trust or any other property that belongs to the trust but is outstanding, you're supposed to go and retrieve it. If there is a trustee who, under suspicious circumstances, was asked to leave, you are to investigate what are the causes of those situations, and if there is anything that is, you know, an issue with that, so they might have transferred some properly incorrectly, you're supposed to go and remedy that breach as a trustee. So trustees are also to act unanimously. And therefore, where there are multiple trustees, you have to come to a consensus of what you're doing with the trust property. Anything that is done by one trustee, where there are multiple trustees, will not be enforceable against the trust. Where, however, your beneficiary is, or your, you know, the settler says that, you know, and the trust deed says that, you know, one person acting alone is fine, then that's acceptable. But generally, they're supposed to be acting unanimously. Trustees are also, you know, liaisons with your accountants because they're supposed to be keeping financial checks on what is happening with the management of the trust and any monies coming into the trust. Any monies generated from the trust property, the trustee is supposed to know all of this information. They are to make trust property productive, so they're supposed to do investments if necessary to make sure that the trust property is gaining, is being fruitful. So they're also supposed to be doing investments with the trust property, anything from which capital appreciation can be expected. One of the other duties of a trustee is that they're not really supposed to benefit from the trust. They are to get a reasonable remuneration for their assistance with the trust. And at one point, trustees couldn't benefit at all. But then the law said, that doesn't seem fair. So now they're, you know, they're entitled to reasonable remuneration where the trust deed provides this, and also they're entitled to their out-of-pocket expenses. Now, trustees also cannot purchase trust property for themselves because that will be a breach of their duties. Because then again, you'd have to show some sort of that there was no undue influence. You'd have to show that you paid what was the right amount for it or even more to get off that sort of insinuation. The trustees must distribute the income and capital of the trust in accordance with the trust deed and are personally liable if they give the trust property to somebody that they're not supposed to. So there's also a personal liability there in being a trustee. All right, trusts can be varied. Trust can be varied, but only where the beneficiaries consent to the variation. So generally, there is there's supposed to be no deviation of the terms of a trust deed because this will be a breach of the trust. One way to put an end to a trust is all the beneficiaries who are absolutely entitled can agree that the trust should be put to an end, and where they have made this agreement, the trust is to come to an end, and the trustee must hand over the trust property as the trust deed directs. So trusts as an alternative to wills, some of the pros and cons. So one of the pros of a trust is that you can make provisions for yourself and your beneficiaries while you're alive, during your lifetime. And you can also make provisions for your beneficiaries after you have died. A will only activates once you've died. Setting up a trust is a very involved process, particularly the drafting of the trust deed, in ascertaining all the assets and transferring all the assets to the trust. But as we would have seen, the process of probate and administration, which is a legal process which requires you to file documents into court, this process can be expensive and time-consuming because of all the fees and paperwork. Just a little bit on the tax treatment of, trusts, so you can, make a determination of, looking at your property, whether a will or a trust is more, feasible for you. Where a person dies, there are two types of tax treatments. So where the trust is deemed a revocable trust, which means that it can be, put to an end, assets remain in the settler's estate. So all your assets essentially, so also this is what happens when you don't do the vesting process. The settler's assets remain in their estate and they're liable to pay income tax on any revenue that is generated by the trust. So when the trust makes a profit, you pay income tax on that profit. And when you die, because it's still in your estate, you're going to have to pay estate taxes on that property. Where the trust is deemed irrevocable, which is, you have done all the proper vesting, and also when you die and nothing can be changed, it becomes irrevocable. The assets are removed from your estate and placed into the trust for tax purposes. Therefore, would not be subject to some of the estate taxes and death duties. Where you do that, however, your beneficiaries will still have to pay income tax on any income that is generated by the trust, because nothing happens that the tax administration doesn't want to charge you money for. So it is important to note that with trusts, there are other taxes. So you will have your income tax on, anything that is generated, but there's also transfer tax. So everything that you transfer into the trust will attract a transfer tax. If you do it as a whole, then it is, a set 2% transfer tax on the value of everything that you transfer into the estate. You'll also have to pay stamp duty on the transfer instruments and on the trust deed. So although wills can be costly, trusts usually are more costly because there are transfer tax obligations and stamp duty obligations, which can be a little bit more than the property under the wills. There's also ongoing expenses for management of the trust and any kind of legal compliance for the trust for the entire life of the trust, depending on how many, and that could be a very long time. So, closing remarks. Whether you are young or old, estate planning is a must. This is even so when your estate or your assets are limited. Estate planning allows you to ensure that people you want to receive gifts do indeed become their owners. Where you may have complicated personal relationships, or there is family conflict, or you suspect that family conflict could arise, estate planning is even more crucial to leave clear directions for the distribution of your assets, which could prevent potential disputes. So, this is the end of the presentation. So if you have any more questions, I'm happy to take them.
Well, Sister Lisa, I don't think anybody has to ask any question about whether or not this was of interest. People stayed. People stayed the course. And so I'm not going to move the vote of thanks, but I really want to suggest, we've had a long day. The presentation, as we said, is free. You believe it? Available to you? You can have a printed copy or you can have all of what you saw presented in your email. And it's also on YouTube. This is unbelievable, right? And so, I mean, I'm not going to wear it. I can't imagine that Lisa stood that whole time. I've been trying to look at her to say, sit down. But she was just there going. There's no question about whether or not she is a dedicated and committed attorney at law. So, Lisa, kudos to you. This was so much information. Um, is there anybody who is burning with a question? Because otherwise, hello, she's a businesswoman. So she's not about to give you all free consultation. She has an office. Would you tell us where your office is, Lisa? So they can see you?
My office, next slide, is at office number 594C Old Hope Road. If you want to write down any of those emails, that's my email and Christopher's email.
All right. So guess what? She has whet the appetite. She has given you a lot of food for thought. You may see her in her office. You understand? You get this free. The rest of it will not be free. So, is there a burning question? I'll take one. Sister Lamita, we're going to send you to the office,
Again, something very.
All right.
All right. I am really happy that you give us all this information because I know it's costly. Anyway, my burning suggestion. I had a property. My spouse has a property. I don't want to leave my property, but his asset is not as big as mine or expensive as mine. And if he comes to live with me, would I have to share?
Yes.
Where I said to me, well, I am really happy to hear because I won't be sharing it.
All right, I'm going to ask one question, which I think maybe a lot of persons want to. If you have something and it's owned jointly,
Yes.
joint tenants, can joint tenants come together to make a will?
Right. So if you have joint tenants, it doesn't quite make sense for you to come together to make a will. You should have your own will for your own things that you might not jointly own with the person, and they should have their own will for things that they don't own with you, and whichever one of you goes first, it will just automatically be yours, the person who survives. So there's no real benefit to putting anything, doing any joint will.
We die together. Mama wants to know. You want to ask a question? Suppose you both die together. Hardly likely. It's an act of God. Thank you, Lord. The rapture is here.
I mean, if you both die together, that property is going to, unless you've made some sort of provision for it.
All right, so the fact, all the mic tired. So, Lisa, I mean, I can't tell you how much information I've gained, but we have somebody who's formally going to say thanks. And so I just want to say, on behalf of the Women's Fellowship, thank you. She will say thanks on behalf of the church.
Sister Lisa, it has been a privilege to sit down and listen to all of what you had to say. I did not know that this will and this trust thing was so big. Because at my age, I was saying to myself, I have a few earrings, and anybody who want to fight over the earrings can fight over it when I'm gone. I don't have anything to put up a will or a trust. but it's so interesting that we've seen you in your drama and your church activity, and you're so good. But this presentation, Lisa, was off the chain. It was so good. And we want to thank you on the behalf of the church for coming and giving us all of this information free, because, Lisa, this is an expensive thing, you know. When you go and sit in front of a lawyer, it's an expensive thing, and you came and you did all of that for us. We are so happy for it, and we are happy, Lisa, that you are a part of us, and we can call upon you. We can call upon you to either in your church activity or to do a presentation for us, and we want to say, on the behalf of the church again, thank you, Lisa. All right. And we have this little token for you. I hope you appreciate it. Thanks. Yeah.
Thank you very much. I hope you enjoyed the presentation.
Thank you all for staying. Thank you. I am sure. All right, thank you.